of the Constitution. See, amendment of the Constitution. Amendment means changes. Can you make a change in the Constitution? Can you add new articles in the Constitution? Can you delete old articles from the Constitution? Can you remove? There are some constitutions which are difficult to amend. They are called rigid constitutions. There are some constitutions which are difficult to amend. They are called rigid constitutions. There are some constitutions which are easy to amend. They are flexible constitutions. American Constitution is an example for rigid constitution. British Constitution is an example for flexible constitution. American Constitution is an example for rigid constitution. British Constitution is an example for flexible constitution. Indian Constitution is a unique blend. It is a unique blend of rigidity with flexibility. Indian Constitution is a unique blend of rigidity with flexibility. If you want to make anything very rigid, definitely there won't be permanence in that. If you create a very rigid rule book, nobody will respect it. If you create some provision for changes according to the changing times, people will respect it. Say for example, your grandparents wrote a rule book for your family. Your grandparents wrote a rule book for your family, which includes your dressing style, food style, hairstyle, lifestyle, employment, all these things. And in that rule book, your forefathers said, nobody should touch and change any rule. Future generations should completely follow all the rules. Future generations should completely follow all the rules. With some respect, your father might follow it. Will you follow it? Will your future generations follow it? You will completely throw away the book. There are many countries in the world and they have changed many times their constitutions. There are many countries which change their constitutions many times in the world. France have many constitutions. Russia have many constitutions. So they keep on writing their constitutions, rewriting their constitutions. But Indian Constitution, which came into force on 26 January 1950, till date got amended successfully and kept itself accustomed with the changing times, accommodated with the changing times. But the core sanctity of the Constitution remained intact. The core sanctity of the Constitution remained intact. We had 103 amendments, amendment acts. Still our Constitution remained intact and we have accommodated for the changing times. Pandit Jawaharlal Nehru said, while we want to make this Constitution solid and petrified, we can make it. While we want to make this Constitution solid and petrified, we can make it, but there is no permanence in such Constitution. That Constitution cannot be permanent. When the world is in a period of transition, what we may do today might not be applicable tomorrow. When the world is changing, what we may do today might not be applicable tomorrow. The only thing that is permanent in the world is change, remember. The only thing that is permanent in the world is change. Any text, any rule book, if it did not provide for a change, it will be thrown in the waste basket. For that reason, there should be a need for change. There should be a provision for change. So Indian Constitution also had a provision for change. As I told you, Indian Constitution is a blend of rigidity with flexibility. Indian Constitution is a blend of rigidity with flexibility. Rigidity with flexibility blend means important articles difficult to amend, normal articles easy to amend. Indian Constitution contains an article, Article 368. Article 368. It deals with power and procedure for amendment. It deals with power and procedure for amendment. There might be a prelims question. There might be a prelims question. Article 368 deals with power for amendment, procedure for amendment, power and procedure for amendment, like that. Article 368 deals with power and procedure for amendment, not just for power for amendment. It also deals with power and procedure. Coming back, law making power of the parliament is called legislative power. Constitution amendment power is called constituent power. Article 368 deals with constituent power, not legislative power. Again a prelims question. Article 368 deals with constituent power, not legislative power. Don't get confused. Law making power is different, constitution amendment power is different. Law making power is called legislative power. That is a different process. Constitution amendment power is called a constituent power. That comes in Article 368. So Article 368 deals with constituent power. Constituent, constituent, it's called constituent power. Article 368 deals with three types of amendment. Article 368 deals with three types of amendment. Follow this carefully, very important. Article 368 deals with three types of amendment. Amendment by simple majority, amendment by special majority, amendment by special majority along with the ratification of half of the state legislatures. Amendment by simple majority, amendment by special majority, amendment by special majority along with the ratification of half of the state legislatures. Amendment by simple majority means in the members present and voting, if majority of the members say are favorable to that amendment will be carried forward. Amendment by simple majority means majority of the total members present in the house, then you can have amendment. This is called amendment by simple majority. In a particular day, among the members who are present, if majority accept it, that amendment can be carried forward. Article 5, Article 169, Article 239 capital A, they can be amended through amendment by simple majority. Article 5, Article 169, Article 239 capital A. These articles can be amended through amendment by simple majority. This is called simple. Second type of amendment is amendment by special. Amendment by special. This you should understand very carefully. What is amendment by special majority? Amendment by special majority means the majority of the total strength of the house. For example, the total strength of Lok Sabha as on rolls was say 545. Majority of the total strength of Lok Sabha. This is not enough. There are two conditions. Majority of the total strength of the house and 2/3 of the members present and voting. 2/3 of the members present and voting. And both should be fulfilled. That means on a particular day when the constitutional amendment bill was passed, 2/3 of the members present and voting should vote in favor of amendment. 2/3 of the members present and voting, and this 2/3 who favored the amendment should be majority of the total strength of the house. It should be majority of the total strength of the house. How many of you understood this? How many of you did not? I will explain again. See, last week we have Dasra. Most of you went for Dasra holidays. See, our class strength is 100 and most of you went for Dasra holidays. On the present day, on the Dasra day, before Dasra day, only 50 are present. Only 50 are present. So, what happened? We want to have some amendment. Out of 50, an amendment bill was proposed, 35 voted in favor of the bill. What is 2/3? 33. But 35 voted in favor of the bill. 35 favored the bill. Can the bill be passed? No. Because when a serious amendment, when an important thing is being made, when some change is being made, majority of the total strength of the house should also agree. Is 35 a majority of the total strength? Was the total strength 100? But 33 is a majority of the strength present, but not majority of the total strength. Okay, so any amendment on special majority should have 2/3 of the members present and voting should support it. It should be supported by 2/3 members present and voting, and this 2/3 should be majority of the total strength, 50% plus 1. For example, in a class of 100, 50% means 50 plus 1, 51 should support, not 35. Got it? Special majority means 2/3 members present and voting, and it should also include total majority of the total strength of the house. Then only constitutional amendment will be carried. Why this special majority rule? Because constitution is the supreme law of the land. Its amendment should not be carried by the minority support. Majority of the people's representatives, majority of the MPs, who are MPs, people's representatives, should support that. Only then the amendment will be carried forward. The amendment will be carried forward. So, special majority means 2/3 members present and voting, and this 2/3 should be majority of the total strength of the house. That means 50% plus 1, majority of the total strength. So, in the total strength majority should approve, and this majority should be minimum 2/3 of the present members present and voting. The third type of amendment is special majority, which we have discussed now, along with ratification of half of the state legislatures. Special majority along with the ratification of half of the state legislatures. That means the articles which affect the states also, like election of president, extent of executive power of union and states. Whenever you are mentioning this, in brackets you should write articles so that you will get more marks. Article 54, 55 deals with election of president, extent of executive power in union and states, Supreme Court and High Courts, articles dealing with Supreme Court and High Court, 214 to 124 to 147, 214 to 231, articles dealing with Supreme Court and High Courts, and center-state relations, like financial relations. For example, recent GST bill, states also gave their ratification. Earlier NJAC bill, National Judicial Appointments Commission bill, states also gave their ratification. Center-state relations. Then 7th schedule deals with list, union list, state list, concurrent list. Any amendment in the 7th schedule, state ratification is also necessary. 4th schedule means representation of states in Rajya Sabha, representation of states in Council of States. In the 7th schedule, 4th schedule, and also when you are amending article 368, when you are amending the amendment article, then also states ratification is a must. So, election of president, extent of executive power of the Union states, issues related to Supreme Court and High Court, center state relations, 4th schedule, 7th schedule, Article 368. In these cases, ratification of half of the state legislatures is a must. Ratification of half of the state legislatures. So, there are 3 types of amendments: amendment by simple majority, amendment by special majority, amendment by special majority along with the ratification of half of the state legislatures. The articles which do not come under first simple majority and special majority along with the ratification of half of the states will come under second type, that is called special majority. A constitutional amendment bill can be introduced either in Lok Sabha or in Rajya Sabha. A constitutional amendment bill can be introduced either in Lok Sabha or in Rajya Sabha. President cannot reject, after a bill is passed by both houses, President cannot reject a constitutional amendment bill. An ordinance cannot be issued for constitutional amendment because ordinance making power is a legislative power, not a constraint power. Constitutional amendment power is a constraint power. An ordinance cannot be issued for constitutional amendment. And in India, we have 103 constitutional amendments till date. Constitutional Amendment Bill is different, Constitutional Amendment Act is different. For example, 108 Constitutional Amendment Bill, Women Reservation Bill is lapsed. So, do not get confused. Constitutional Amendment bills may be introduced, but it might have not been passed. So, we have to count Act separately, Bill separately. Do not get confused between Constitutional Amendment Bill and Constitutional Amendment Act. This is about Article 368, power and procedure for amendment. Okay.